Thank you all for coming today. My name is Robert DeReese. I'm the Chief Justice of the Moot Court Board, and I'm very pleased to welcome you to the final round of the 80th Annual William Minor Lyle Moot Court Competition. The competition honors the memory of William Minor Lyle, a law professor of over 40 years at the University of Virginia and the first dean of the School of Law. The Lyle competition was first held in 1929, and it's among the most rigorous moot court competitions. It consists of 5 individual rounds, brief writing and oral arguments on problems provided by the Moot Court Board, spanning a full 2 years of law school. The first and second rounds are held during one's second year and are judged by third-year students. The quarterfinal round, held during the fall semester of one's third year, is judged by members of the law school faculty. Winners from the quarterfinal round then go on to participate in the semifinal round, and the winners from that are here today. And those last 2 rounds are judged by distinguished federal judges. Approximately 200 students began the 80th annual competition. The 4 competitors who are here today, who have advanced to this final round, have fielded tough questions from law students, the faculty, and federal judges. And through it all, the finalists have proven themselves to be among the finest speakers and advocates at the law school. It's my pleasure now to introduce Kara Cohen, the semifinal round and final round presiding justice, who will introduce our panel of judges, the problem, and the competitors. Thank you.
This afternoon's finalists are Aaron Shepard and Landon Allred for the appellant, and Benjamin Holley and Lee Peifer for the appellee. The case before the United States Court of Appeals for the 21st Circuit is Andrew Tiller versus the Attorney General of the State of Lyle and George W. Kipling, Warden, Country County Department of Corrections. The case is on appeal from the United States District Court for the Eastern District of Lyle. The litigants will address the following issues on appeal. The first is whether petitioner can prove actual innocence of the sentence received should petitioner be eligible for equitable tolling of the statute of limitations under the Anti-Terrorism and Effective Death Penalty Act. The second is where petitioner was sentenced under a habitual offender statute, but petitioner can prove that he was not, in fact, convicted of 2 separate felonies prior to sentencing as required by statute, can petitioner make an actual innocence claim to challenge enhancement of his sentence? I'd like to take the opportunity at this time to introduce this afternoon's distinguished bench of Federal Circuit Court judges. Judge G. Stephen Agee was appointed to the bench by President George W. Bush in 2008. Judge Agee received his Bachelor of Arts from Bridgewater College in 1974. He then attended the University of Virginia School of Law. Upon receiving his JD, he attended NYU School of Law and earned his LLM in taxation. He has litigated in both Virginia and federal courts. Judge Agee served in the Virginia House of Representatives from 1982 to 1994 and was a member of the United States Army Reserve from 1986 to 1997. In 2001, Judge Agee entered the judiciary as a Court of Appeals judge for Virginia. He served on the bench of the Virginia Supreme Court from 2003 until his appointment to the 4th Circuit. Judge Julia Smith Gibbons was appointed to the bench of the 6th Circuit by President George W. Bush in 2001. Judge Gibbons obtained her undergraduate degree from Vanderbilt University, where she was a member of Phi Beta Kappa. She continued her studies at the University of Virginia School of Law, where she was a member of the Virginia Law Review. Following law school, Judge Gibbons clerked to the Honorable William E. Miller, U.S. Court of Appeals for the 6th Circuit. She entered private practice in 1976 and began her judicial career as a judge for the Tennessee Circuit Court in 1981. From 1983 to 2002, she sat on the bench of the U.S. District Court for the Western District of Tennessee, serving as chief judge from 1994 to 2000. Judge Jeffrey Sutton was appointed to the 6th Circuit by President George W. Bush in 2003. Judge Sutton received his Bachelor of Arts degree from Williams College in 1983. Before attending law school, Judge Sutton taught history at the Columbus Academy. He then attended law school at the Ohio State University Moritz College of Law. Upon receiving his JD in 1990, Judge Sutton clerked for the Honorable Thomas Meskill of the 2nd Circuit. He then clerked for the United States Supreme Court Justices Scalia and Powell. Upon completing his Supreme Court clerkships, Judge Sutton entered private practice. He served as state solicitor for Ohio from 1995 to 1998 and has served as an adjunct professor of law at the Ohio State University Moritz College of Law since 1994. On behalf of the William Minor Lyle Moot Court Board and the University of Virginia School of Law, we'd like to warmly thank this afternoon's judges for taking the time to prepare to hear the arguments and for traveling to Charlottesville to participate in our 80th annual competition. Before we begin, I would like to thank Christina Lynn for composing the final round problem. It presents interesting and challenging issues and should serve for lively oral arguments. I'd like to remind you at this time to please mute or turn off your cell phones. Thank you all for coming, and we hope you enjoy this afternoon's arguments. Christina Lynn will serve as clerk of the court.
All rise. Hear ye, hear ye. All those having business before this honorable court come forward and be heard. The Honorable Jeffrey S. Sutton, Julia Smith Gibbons, and G. Stephen Agee presiding. The United States Court of Appeals for the 21st Circuit is now in session. Case number 08102 on appeal from the United States District Court for the Eastern District of Lyle. Andrew Tiller, appellant. Attorney General of the State of Lyle, George W. Kipling, Country County Department of Corrections, Appellees. Counsel for the appellant, do you reserve time for rebuttal?
Yes, 2 minutes.
Good afternoon. Welcome to the United States Court of Appeals for the 21st Circuit. We're ready to begin with the argument of the appellant.
Good afternoon. May it please the court, my name is Landon Allred, co-counsel along with Aaron Shepard for the petitioner in this matter, Mr. Andrew Tiller. Your Honors, today this court is asked to determine whether the state can hold an innocent person in prison for 10 years due to a procedural default, or whether that person will be allowed to present uncontested evidence of innocence and have his claims heard on the merits. The facts in this case are fairly simple. In May 2003, Mr. Tiller was convicted of a felony and received a 10-year sentence. In addition to that 10 years, he received another 10 years under the State of Lyle Habitual Offender Statute. However, that statute requires 3 unrelated felonies. Mr. Tiller has committed 3 felonies, but the first 2 arose from the same incident and are therefore not unrelated as required by the statute. Mr. Tiller pursued his direct appeal on grounds other than those before the court and was represented by counsel. That petition was denied. Then, acting pro se from prison, Mr. Tiller realized that his counsel had not raised the issue that he's ineligible for this additional 10-year sentence. He submitted a petition for state habeas relief and was denied because the grounds had not been raised on his direct appeal. He then brought the claim before the federal district court for federal habeas relief and was denied because the claim came 9 days after the statute of limitations had run, and the court also noted that the issue had not been raised on direct appeal. Mr. Tiller now brings his claim before this court for adjudication. I will address the statute of limitations issue, and my co-counsel will address the procedural bar. Your Honors, the actual innocence exception applies to the AEDPA statute of limitations for 2 reasons. First, the AEDPA incorporates the Supreme Court's tradition of applying the actual innocence exception to all threshold procedural matters. And second, given this court's special responsibility to protect the core concern of the writ of habeas corpus, the actual innocence exception applies.
Counsel, what do we do with the fact that 2244D, after the EDPA was enacted, has an awful lot of specific exceptions for when this limitations period runs? One in particular seems quite troubling for you in 1D, which talks about whether the factual predicate of the claim presented could have been discovered through the exercise of due diligence. So if we decide here no due diligence when it comes to your client, it seems to me we ought to look at that provision and say, how can we possibly grant relief without effectively writing it out of the statute?
Well, Your Honor, the actual innocence exception exists as a wholly separate exception from the cause and diligence requirement. That's what the Supreme Court held in its Carrier decision in 1986.
Now, does that mean that you're not, that you're calling this exception something other than an equitable tolling of the statute of limitations?
Well, it's an equitable tolling of the statute for actual innocence. It's not a very.
Well, are you familiar with equitable tolling in any area of the law where diligence is not a component of the requirement for tolling the statute?
Not with tolling specifically, but with regards to general procedural bars, actual innocence is allowed regardless of whether the petitioner can show cause and prejudice. The cause and diligence requirement is merely a statute of limitations analog to the cause and prejudice requirement, which the Supreme Court's decisions in Carrier and in Coleman and in Schlup have supported.
Can you point to any exceptions to the statute of limitations in this area or any other where the ultimate merit of the claim is a factor in determining whether the statute should be told or disregarded?
Well, Your Honor, the Sixth Circuit's decision in Souter, or the Supreme Court's decision in Souter, which was on appeal from the Sixth Circuit, allowed the actual innocence exception. The Sixth Circuit allowed the actual innocence exception regardless of whether there was cause and diligence. So it did look at the underlying merits of the claim in determining whether the exception was allowed.
Is that really true, that it was regardless of whether there was diligence? I thought that was a case where it came forward with completely new evidence, experts recanted, witnesses recanted. It seems to me it was a case where you could look at it and say they did everything they could do.
No, Your Honor, in the Sixth Circuit's decision, it noted explicitly that Souter had not met the diligence requirement because under Section D1D, as you point out, if he had brought the claim within 1 year of discovering the evidence, then he wouldn't have been required to receive the actual innocence exception.
How about the fact that in Souter it was new evidence? Here we don't have new evidence.
Well, it's true that there were certain elements of the evidence that Souter presented which were new, the recantation of testimony.
There is no new evidence.
Correct. Well, there's new evidence in that it wasn't presented at trial, which is the same situation that there was in Souter. One of the elements that the court found persuasive in Souter.
No, but in Souter you had a case where you have witnesses recanting. That's not what's going on here. Here the only thing new is realizing you have a claim. That's not new evidence.
New evidence, as the Supreme Court defines it in its Schlup decision, is evidence that was not
Schlup was pre-EDPA, right?
What?
Schlup was pre-EDPA.
Yes, it was.
So is that still relevant?
Yes, according to the Supreme Court's decision in House in 2006, the AEDPA survives, or the actual innocence exception survives the AEDPA.
Was that actual innocence that goes to the offense, which was clearly the case in Sutton, although it had a death sentence exception? But we're talking about sentencing here, and only sentencing. That sort of takes it back to Judge Sutton's first question, because you have what would appear to be the clear language of the statute that doesn't provide for the equitable tolling argument that you're making here.
Well, the clear language of the statute, as the Supreme Court has noted, statutes of limitations are customarily subject to equitable tolling unless the Congress provides otherwise. With regard to the AEDPA, every single federal circuit, 1 through 11, has allowed equitable tolling, despite the fact that there's nothing in the statute or
So the only way you lose is if the statute says no equitable tolling allowed. That's the way this has to work. Congress has to look ahead and say, oh, there's an actual innocence exception here, there's another one here, you can bring it late if you exercise due diligence here, but we ignore all of that and all the implications and inferences from that. Congress still has to spell it out and say no equitable tolling allowed.
The Supreme Court's language is that there has to be a clear and valid legislative command or a necessary and inescapable inference from the statute. Every federal circuit has found that the AEDPA does not contain that language and has incorporated the equitable tolling provision of the Carrier test. Therefore, in order for the government to win on this issue, there must be some principled reason to apply only the cause and prejudice test from Carrier and not apply the actual innocence exception. And there's not. As the Supreme Court noted in Day in 2006, it would be irrational to distinguish the statute of limitations from other procedural bars, citing habeas rule 5b, which puts the statute of limitations on the same grounds as procedural bars, failure to state a claim, or non-retroactivity. And in the further Supreme...
If we have these equitable tolling doctrines, then what role does 2254B play? I mean, what are these exceptions? Do they have any role to play? Aren't they just superfluous? If we're reading in equitable tolling generally, we would read it in there too, wouldn't we?
Yes, Your Honor. It's actually unclear
So the words just weren't worth anything in that section.
The Supreme Court in its House decision said the 2254B and 2244D1D were not applicable to a petitioner's first federal claim claiming actual innocence. So while the interpretation is not exactly clear, it does so in one sentence. The Supreme Court has pushed those to the side when you're dealing with a first federal claim claiming actual innocence, as the court is today. This is even more persuasive given that in this case the government isn't even arguing that the petitioner is guilty or ineligible for this 10-year sentence. They've conceded that he is ineligible for this sentence and therefore are recognizing his actual innocence. Given the core concerns of our criminal justice system and the core concern of the writ of habeas corpus to protect against the conviction of an innocent person, and given this court's special responsibility to help shape the writ, it has a duty to allow this core concern to be protected.
What purpose do the specific provisions in statute 2244 and 2254 that deal specifically with actual innocence in terms of the underlying offense? So that's stated in several places in both statutes. What purpose does that language in the statute have if we adopt your position?
Your Honor, this is an exception to the statute. So just in the same way that the exception wasn't written into the statute in Carrier or in Coleman or in Schlup, it's not written into the statute here. This is a judicially created equitable exception.
But he's making the point that there are other exceptions, and if we read this exception in, those other exceptions have no purpose anymore. That's the problem.
Well, they do have a purpose, because if a petitioner can satisfy those exceptions, he doesn't have to meet this gateway of innocence exception. The actual innocence exception is only a gateway whereby a petitioner can have his merits heard. If he meets the statute on its terms, then he doesn't have to satisfy the gateway requirement.
You know, this argument seems to me to bring the statute of limitations argument and the procedural default argument together in a way that doesn't take into account the different purposes of a statute of limitations and the procedural default cause and prejudice doctrine. Do you accept the notion that a statute of limitations exists for a reason that's independent of the reasons that procedural default exists?
Yes, they do have independent justifications, but that's not a reason to treat...
What do you think the independent justifications are?
I believe that a timeliness issue is more directed towards getting the claim reheard if the state would like to retry the case, so that it can do so while the facts are still fresh, while the procedural bars are to help in the judicial administration so that people aren't bringing multiple claims. But the Supreme Court in Coleman said that it would be irrational to treat them differently in the equitable context. The logic being...
Does the limitations period have a relation to when a petitioner, a person convicted in state court, should be able to bring the federal habeas cause of action?
I'm sorry, I don't understand your question.
Well, procedural default is we look at what happened in the state court. Seems to me that with the limitations period, we're looking at the initiation of the federal cause of action and when a petitioner should be able to initiate that, which is a wholly different set of considerations that seem to go to the federal interest in not hearing stale claims, to the whole notion of federal-state relations and comity, and the idea that the writ ought to be available only when certain federal procedural requirements are met. Do you buy any of that?
Yes, Your Honor. But the Supreme Court has held in 1998 that the fundamental purpose of the AEDPA was that criminal adjudications not be revisited in the absence of a strong showing of actual innocence. The purpose of the AEDPA incorporates this actual innocence exception, and the Supreme Court has continued to apply it for the past 20 years, even as Congress has ratcheted down on the availability of the writ. So
where is this going to apply? So your conception of actual innocence goes beyond just whether you're innocent of the crime. It goes to this innocence of the sentence, right?
Yes, Your Honor.
So I take it would apply any time someone is serving a sentence longer than they think they should. Isn't that correct?
No, Your Honor. As my co-counsel will address in more specificity later, the rule would be the Sawyer test, the eligibility test. So if a person is required to serve a sentence for which there is an eligibility test, and that a person does not qualify under the eligibility test, then they would be able to bring an actual innocence exception.
How does Sawyer get you to that point? The Supreme Court seemed to be fairly specific there, that it was an easy case to determine whether there was actual innocence of the underlying offense. You can go to the man on the street and know what that means. But they seem to be fairly clear in not wanting to get into actual innocence, even though that's somewhat of a misnomer. actual innocence in a sentencing context, except in a death case. So how does Sawyer help you?
Your Honor, the eligibility test or the availability of this actual innocence exception was more defined in Smith, which said that the court would not look to the penalty which they were considering. In Sawyer, they were dealing with a death case, so their holding was a death case. But the rule is the eligibility test.
How about in Dretke? They had the opportunity after Sawyer to answer your question. They went out of the way not to answer it.
Yes, Your Honor. The court has directed lower courts also to decide the issues on easier grounds rather than dealing with this actual innocence exception.
Usually the easiest ground is lack of due diligence, isn't it?
But again, that's different than the actual innocence exception. If this court, leave to finish my answer. This court is faced with an unquestionable showing of actual innocence, so it doesn't have the luxury of avoiding the difficult question as the Supreme Court did. And for that reason, we ask this court to allow Mr. Tiller to have his claims heard. Thank you.
May it please the Court, my name is Aaron Shepard, co-counsel for the petitioner, Mr. Andrew Tiller. Mr. Tiller's uncontested ineligibility for the 10-year sentencing enhancement that he received is sufficient to overcome his procedural default for three primary reasons. First, the great weight of Supreme Court precedent in the habeas corpus context. Second, the compelling analysis of this court's sister circuits faced with similarly situated petitioners. And third, the principles and policies which underlie the writ of habeas corpus. First, the great weight of Supreme Court precedent. In announcing the actual innocence exception in the trio of cases decided in 1986, the Supreme Court noted specifically in Carrier that the purpose of actual innocence was to fulfill the equitable concerns of habeas, specifically the court's concern that an innocent petitioner would sit in jail for either a crime he did not commit or a sentence he was...
Can I ask you an introductory question? I'm curious, when I think of cause and prejudice and actual innocence, I think of it as a gateway to another constitutional claim. What is your independent constitutional claim here? Is it ineffective assistance?
No, Your Honor, it's a due process violation because of insufficient evidence.
So your gateway claim is your constitutional claim?
In this case, it is somewhat circular, but that is the problem.
But I thought, in Herrera, the court had a chance to say that actual innocence is a freestanding constitutional claim. They didn't do it there. That was, what, 93? The court's never done that. It seems they've been pretty reluctant to make that a freestanding constitutional claim. So what's the whole point of this activity? Gateway, seems like a gateway to nothing, or a gateway back to where you were when you started?
Well, Your Honor, it's a gateway to vindicating that underlying due process constitutional right. That's what the Fifth Circuit recognized in Haley when it was faced with a petitioner who was sentenced under an enhancement statute, and he was not eligible for that statute. It found there that there was the underlying due process violation. And in Herrera, the Supreme Court didn't foreclose the opportunity for a gateway actual innocence claim that was perhaps more freestanding. And in fact, one of the concurrences noted that where there was an extreme case, one that was an even higher standard.
Do you lose if we think there's no such thing as a freestanding constitutional claim premised solely on actual innocence?
No, Your Honor. Here, the actual innocence gateway leads this court to the underlying due process violation. Again, it is somewhat circular.
So it leads you to a losing claim?
No, Your Honor. Here, there was insufficient evidence for the sentence that was imposed on Mr. Tiller.
But that's a state law problem. That's a problem of state law.
Your Honor, that is a due process violation, that insufficient evidence to convict. And so that's the underlying...
There wasn't insufficient evidence to convict Mr. Tiller. What there was a mistake of fact as to whether or not his two prior convictions were unrelated, correct?
Yes, Your Honor. I'm sorry I misspoke. To be convicted of that enhancement, that habitual offender enhancement.
To have had, well, he wasn't convicted of the habitual offender enhancement. That was imposed upon him as a part of his sentencing judgment, correct?
Correct, Your Honor.
And your position is that that's a due process violation akin to the due process violation that would exist if the evidence at trial to establish the instant offense, that if there had been sufficient evidence to convict of that, correct?
Yes, Your Honor. This extension of the actual innocence exception is supported by the fact that in Carrier and in Smith, the Supreme Court never distinguished between different types of sentences. In Smith specifically, the court noted that
They certainly distinguished in Sawyer.
yes, Your Honor, there the court in a couple vague passages did contrast.
They were pretty specific in Sawyer. You've got actual innocence of the crime, you have death, you have everything else. And they drew a pretty clear line that the only sentencing option we're taking up in the actual innocence context is death. How do you get past that line?
Well, Your Honor, in Sawyer, the court didn't need to draw such a clear line. That line had already been drawn by the court in Smith.
Well, they may not have needed to do it, but it certainly looked like they did.
What the court was doing there was giving content to the eligibility test. The work of determining whether or not the actual innocence exception would apply to that particular petitioner had already been done in Smith when the court noted that innocence of a sentence would be conceptualized under actual innocence. So in Sawyer, the court was looking at the contours of the eligibility test and how to ensure that.
Why didn't they say that in Dredge?
Well, in Dredge, Your Honor, the court simply remanded on a narrower grounds. It had opportunity.
I understand that, but it kind of begs the question. Your exact issue was before the court. That's how Justice O'Connor started off the opinion, framed the issue. Of course, they dodged it after that, but they had the perfect opportunity to answer it.
They certainly did, but they had the perfect opportunity to answer it either way, to say that Mr. Tiller's claim would be able to go forward or to say that it wouldn't, and they simply didn't answer the question. And so this court faces the group of precedents that was available pre-Dredge.
This is the way it always works. The Supreme Court decides the easy cases, we decide the hard ones. So your co-counsel said he would deliver the goods on this issue. So I understand the stark nature of this particular claim, but there are lots of defendants out there who have after-the-fact claims that their sentences are too long. For example, in the post-Booker world, there's all kinds of arguments about people saying, well, you know, if I've been sentenced under the prior regime, I would be sentenced to less. Or you have changes in the interpretation of a statute, so it no longer covers a sentencing enhancement. I take it, if you win, all of those individuals can bring this, quote, actual innocence claim without regard to any of these other issues that normally apply, whether it's due diligence or cause and prejudice.
Not necessarily, Your Honor. The key is the eligibility test that Sawyer announced. In Sawyer, the Supreme Court actually has done the work for this court in making sure that the remedy is contoured to keep the group of cases that came through narrow and definite.
I don't understand. If I think of Sawyer as a death penalty case, that of course doesn't help you. So what exactly do you mean by that?
In Sawyer, the eligibility test looks to, was the petitioner sentenced based on some set of eligibility factors? Is there a narrow class of relatively obvious evidence that this court can look to and say, based on that evidence, the petitioner is either...
So that would always apply when the scope of a statute is changed. So the scope of a criminal statute is narrowed. After the fact, people can come in no matter how long it is because they're, quote, actually innocent of the crime, right?
Well, that would be retroactive, Your Honor. In this case, the court looked to the circumstances as they...
But what's the answer to that question? Those people can come in, right, after the fact?
They could come in. I do not believe that their claim would be heard because it would not fall within the test that the court announced.
Why is that fair? These are people that were indicted, convicted, sentenced under a statute that no longer covers their conduct.
That's true, Your Honor,
They're
but...
just as innocent as your client.
I mean, in that case, the state has come back and changed the scope of its criminal laws, which is which it is entitled to do. And if this court feels some sort of sympathy for those petitioners, my client would certainly not object to that. However, we're not asking for that broad of a rule. We're asking for the court's rule in Sawyer, where whether or not the person is actually innocent depends on the type of sentence they received, whether it was an eligibility type sentence or not. And although that does draw, admittedly, somewhat of an arbitrary line, which will leave some petitioners without a claim, it is a line that the Supreme Court has drawn. And so this petitioner is merely asking that the Supreme Court's test be applied in his case.
If you're going to allow us to draw lines, why don't we just draw lines at the death penalty and true actual innocence in the sense of being innocent of the underlying crime as opposed to the sentence. That line seems to me just as fair as the one you're proposing, because you're saying people are going to be left out cold either way.
Your Honor, the Supreme Court in the habeas context has never drawn the line at death. In fact, it has done the opposite. There is no distinction between death and any other type of sentence in habeas jurisprudence. That's what the
Case support for that is.
Smith v. Murray, Murray v. Giartano, there the court said,
Now, where do they say that you get to make your actual innocence claim on sentence?
well, the court in Smith v. Murray notes that the availability of this procedural default doctrine does not depend on the nature of the remedy that the state imposes.
So how's that different between judicial musing and deciding the case based on principle?
Well, Your Honor, there the court was actually arguing against the dissent's argument that because the petitioner before it was a death penalty petitioner, that his case should somehow go forward either under a lesser standard or under really no standard at all, just because of the gravity of the death sentence. And the majority of the court in Smith rejected that argument and said, on habeas, we're not concerned with the type of sentence you received in terms of it being death sentence or not. We're concerned about whether you were actually innocent of the underlying crime or of your sentence.
So your position, I'm sorry.
Putting aside for the moment Supreme Court precedent and focusing instead on policy arguments that might be made in support of your position, there's a pretty obvious argument that death is different. What's the argument that your client should be entitled to the same type of treatment as a defendant sentenced to death?
Well, Your Honor, that's, and I apologize for...
This seems much more trivial to me, and I don't mean that 10 years is trivial, but it just seems to me if we're looking at a continuum, your client would be kind of at the bottom of it in terms of the sorts of things that might be characterized as actual innocence.
Your Honor, that is certainly a natural reaction in looking at a spectrum, and I apologize for returning to Supreme Court precedent. But in Murray v. Giartano,
We look at that too.
but in Murray v.
We're going back there.
But in Murray v. Giartano, the court did say specifically, we have never held that a different standard of review applies because...
What if we aren't looking at Supreme Court precedent? I mean, there's nothing no Supreme Court precedent binds us on this issue. What if we're just trying to find the right answer?
Well, Your Honor, the only difference between a death sentence and any amount of extra time is the inherent finality of the death sentence. And here, Mr.
The only. I mean, that's a big difference. It's not reviewable after you die. That's the big thing.
That's correct, Your Honor, but after this court says to Mr. Tiller, your case can go no further, his judgment is final, and he will spend 10 years in prison, above what even the state says that he is eligible for. And to say that you have to sit in prison for those 10 years because you didn't have the good fortune of being sentenced to death is a perverse incentive on the part of this court. Instead,
Your position seems to be an all-or-nothing proposition based on reviewable law. There are some circuits that have drawn some sort of intermediate line. May not make logical sense, but they have drawn an intermediate line. One of those is to add an exception for habitual offender type statutes. Are you advocating that as a fallback position?
no, Your Honor, the eligibility test that the petitioner is arguing for encompasses habitual offender and career offender statutes because
Well,
those...
Before you make a categorical answer, if we accepted an habitual offender exception like the Fourth Circuit has done, your client would win, correct?
That's correct.
Should you leave a little leeway for that position instead of rejecting it?
I certainly don't reject it, Your Honor, but the eligibility test may in many cases be more narrow than a categorical test saying career enhancers or habitual offender enhancement, depending on how the state chooses to adjudicate those types of sentences, whether it's an offer-on eligibility test. In the vast majority of cases, they will be the same. They will operate in the same way. But the eligibility test actually gives the courts more flexibility to create the equity that is inherent in habeas. And that is why the Second Circuit in Spence did not limit the availability of the remedy to just habitual offender or career offenders
Right.
before
Do
it.
you want to give us a rationale if we decided to draw an intermediate line like the Fourth Circuit has
for drawing the line at career offender, habitual offender enhancements, because those types of sentencing enhancements are extra to the crime. The petitioner has already been sentenced for his criminal conduct. They operate instead as a type of enhancement similar to how the death penalty is not necessarily based on the type of crime that the person committed. It is based on extra aggravating factors. And so that distinguishes it as an enhancement, similar to how the career offender and habitual offender enhancements work on habeas.
Now, both of your argument, your co-counsel's argument, both of them don't depend on whether your client exercised due diligence, and I think the person's argument seemed to be conceding he didn't. What if the facts are a little different? The fellow, after he's indicted, he talks to his lawyer, there's a conviction, and the lawyer says, well, there's a bunch of things here we can do to shorten the sentence, and the guy says, I don't care. If there's 10, 20, 30 years, it makes no difference to me. I'm off to jail. Then he changes his mind 5 years in because he decides he really doesn't care for prison. Is that claim cognizable?
May I have leave to respond?
Yes.
That claim is cognizable, but the incentive will not be.
He just changed his mind.
That's correct, Your Honor. But it is a very narrow class of defendants who would have that kind of a motivation, and that is not the case that is before the court.
People would have remorse after they've been in prison for a while and realize they miss their family, food they like, the air, exercise. It strikes me, there's a lot of people that fall into that category.
It's a very narrow exception, and there are very few people who would have that type of an incentive to wait.
So that's sort of a springing due process claim.
In what way, Your Honor?
As an analogy to property law. It's a due process claim that only comes about when the guy has true regret.
May I have leave to respond, or?
Well, I think perhaps at this point, back to your seat.
Thank you very much, Your Honors.
Proceed.
May it please the court. My name is Benjamin Holley, and along with my co-counsel Lee Peifer, I represent the Attorney General of the State of Lyle. This court should affirm the district court's denial of equitable tolling for two reasons. First, extending equitable tolling to innocence claims is inconsistent with the statutory text and frustrates congressional intent. Second, no court of appeals has held that innocence, standing alone, is sufficient to justify equitable tolling.
You agree without any question that the defendant's habitual offender sentence was erroneous, as a matter of fact?
As a matter, the sentence was improperly applied to Mr. Tiller. That's correct, Your Honor. However, a freestanding innocence claim, which is all that Mr. Tiller brings, is simply insufficient, both for textual reasons in the statute and the doctrine of equitable tolling as it's applied across the circuits.
Well, what interest does the state have in arguing here before us when Mr. Tiller admittedly has been erroneously sentenced?
The state has a strong interest in ensuring that its rules are applied consistently, the rules applying to its prisoners. Here, it seeks to treat all litigants equally when they bring their claims, without looking at the underlying merits of the claim. This is the
Would the
approach.
state support a clemency petition in this case, under state law?
The Attorney General is not authorized to bind the governor in that way, but
You don't have to bind him, just propose it and promote it.
again, we cannot make that assertion here, but Mr. Tiller, of course, is free to ask the governor for clemency. Indeed, the Supreme Court in Herrera noted that executive clemency is the historic remedy for miscarriages of justice. So
What if he applied for a writ of quorum notice?
that might also be available. The Second Circuit in Treastman noted that if habeas is not available, one of the extraordinary writs might be. And again, the state does not take a position on whether it is available or should be available, merely that there are other options. Clemency is certainly available to Mr. Tiller. Habeas, however, is simply the wrong vehicle. He missed the timing, he missed the filing deadline, and there's no actual innocence exception, either in the statute or in equitable tolling.
Is there a state or another state or federal remedy that the state would join Mr. Tiller in seeking?
Again, Your Honor, we cannot bind the state in future litigation in terms of Mr. Tiller. However, he is free, of course, to apply for executive clemency. In fact, that would be a better option because the governor, the executive, is not bound by precedent, not bound by the statutes, or setting any precedent, unlike this court, which, of course, must hew very closely the statutory text. and the precedent that other courts of appeals have noted. In those cases, the courts have generally refused to look at the underlying merits of a claim. The Seventh Circuit in Escamilla...
Let me ask, tell me how you think of this perspective on the case. Initially, I thought, okay, textually, yeah, there's all these specific rules. It's strange for the judges to make up a new one. But then I thought, okay, all the judge-made rules that predated it, they were all responding to a statute. There was a habeas statute in place before then, and courts did what they always did. They filled in gaps. They created exceptions for actual innocence here, equitable tolling there. We're doing the exact same thing. We've got a statute. This one's a little more highly articulated, to be sure, but it doesn't prove that it covers everything. Courts have always done that, and that's all we're doing here.
That's correct, Your Honor. However, this actual innocence exception to the state procedural default was a historic, judicially created exception to a judicially created rule that, importantly, Congress partially codified in AEDPA. There was no such background with a merits-based argument on timing, and Congress did not codify one in 22.
They didn't, they're not omniscient. I mean, well, clearly, they can't anticipate everything. And there's nothing, you've got these broad statements about legislative history, but there's nothing on point to this kind of situation where someone's serving 10 extra years in jail that everyone agrees they shouldn't be serving.
Well, with respect, Your Honor, during the floor debates on AEDPA, as it was actually passed and is now in its current form, several representatives brought up precisely this issue, saying that this timing rules might lead to the conviction of an innocent person. Congress passed the statute as it was. And again, Congress includes exceptions for...
Legislative history on this particular example, not the conviction of an innocent person. That there was legislative history on. This is someone who's sentenced 10 years more than they should have been.
That's correct, Your Honor, though to the extent Congress...
Was there legislative history on that?
Not in terms of a sentencing exception, no, Your Honor.
There we go. We have a situation. They weren't thinking about it. They can't think of everything. Now the issue comes up. We ask ourselves, would Congress have wanted this? We say yes. There's other actual exceptions in the statute. It proves it.
Well, and two responses, Your Honor. The first is that Congress was aware of innocence of an underlying conviction, and did not make an exception. There's no reason they would necessarily want to treat one differently than the other. The second is that, again, this actual innocence exception, as applied by the...
You want to treat one differently from the other. You admit that actual innocence is always your gateway within your underlying offense, right?
For the underlying offense, for state procedural default, that's correct, Your Honor.
So if Congress didn't want to treat the two differently, aren't you admitting that for sentencing purposes you would apply that same rule?
No, Your Honor. In this situation, Congress did not include an actual innocence exception of any kind, conviction or sentencing or otherwise, for the timing rules under 2244D1. That's not the case where they had this backdrop of an actual innocence exception and partially codified it in AEDPA.
So what would be the basis for the Supreme Court's action in Sawyer dealing with the death penalty?
The basis for that was that death is different, as the Supreme Court has noted time and again.
That's not
That's correct, Your Honor. But AEDPA partially removed that requirement from Sawyer. That's not necessarily good law after Sawyer. Though importantly, that's not what is facing Mr. Tiller, since it's not a capital.
You, the state, are taking the position that death indeed is different.
As the Supreme Court has held numerous times, that's correct, Your Honor.
So when we interpret the Fourth Amendment in a case involving an individual sentenced to 10 years, and we interpret the same Fourth Amendment provision in a case involving a capital case, different construction.
Not precisely, Your Honor.
Not at all, maybe?
The legal questions would be different, or the legal resolution would be the same.
Well, right, so that makes death not different, right? We're interpreting the same provision in two different settings, and we interpret it the same. And the state is usually the one that's arguing that.
That's correct, Your Honor.
But here, when it comes to AEDPA, we now take the same words and we give it a different interpretation when we've got a capital case.
The Supreme Court has noted that in capital cases, specifically a capital sentence, there should be more procedural guidelines and death might be treated differently. Again, importantly, this is not a death case. In this case, this court would not need to go that far in resolving the case. Here, Congress established when innocence would justify getting around the timing rules. They did not have a case or text that applies to Mr. Tiller. Moreover, the doctrine of equitable tolling, as applied across the circuits, also does not allow a freestanding innocence claim. The Seventh Circuit, for example, in Escamilla v. Youngworth, simply refuses to look at the underlying merits. The First Circuit in David v. Hall does the same thing.
The bottom line, you tell me if I misinterpret your position, the bottom line
For,
As long as you're dealing with sentencing.
For equitable tolling, there should be extraordinary circumstances and diligence, as the Supreme Court noted in Pace v. Guglielmo and Lawrence v. Florida. Some circuits, the Sixth among them, have relaxed the standard in innocence claims.
Do you
But
lose if we follow the Sixth Circuit standard?
not at all, Your Honor, because as the Sixth Circuit noted in Ross, which was a few months after Souter, there are still important limitations on the Sixth Circuit's rule. Specifically, the petitioner must be attacking his underlying conviction, not a sentence, and he must present new evidence. Neither applies to Mr. Tiller. So, admittedly, the Sixth Circuit is the most petitioner-friendly of the circuits, but even there, Mr. Tiller still would not prevail. And he certainly would not prevail under the approach taken by the First, Fourth, Fifth, and Seventh Circuits, which have all held that the underlying merits have nothing at all to do with why one did not file on time.
Why shouldn't Mr. Tiller be treated more favorably for tolling purposes than a defendant who has a claim that that is just a colorable showing that there may be some question about his underlying conviction? I mean, Mr. Tiller, we know Mr. Tiller got 10 years that he shouldn't have gotten. That's not your typical defendant claiming actual innocence.
That's correct, Your Honor, though again, the state seeks to treat these petitioners equally. To have the merits of a claim heard, the petitioner must either comply with the statutory rules or present a very good reason for not doing so.
Why shouldn't we just fix this problem?
For two reasons, Your Honor. The first is that Congress, again, has already spoken on this issue. And the second is that a freestanding innocence claim nowhere in statutes of limitations previously or in the way that it's applied now is sufficient. Even circuits in dicta willing to consider to relax equitable tolling doctrine, such as the Third Circuit, still impose a diligence requirement. Else, petitioners claiming actual innocence would be able to ignore the statutory timeliness rules, which clearly frustrates the congressional intent, which was to encourage prompt filing. Here, Mr. Tiller could file at any time, regardless, as long as he brings up an innocence claim. That would be an inappropriate result that this court should avoid. Looking to the Fourth Circuit, sitting on Bonk and Rouse v. Lee, they faced a situation where the petitioner was a mere 1 day late, missed the deadline by 1 day, and that was a capital case. But because his claim had nothing at all to do with why he filed late, they refused to hear the merits.
What's your position if it's actual innocence of the underlying crime as opposed to sentence?
In terms of equitable tolling, it would not change.
Would it make a difference? How about if there was due diligence? That wouldn't change?
If there was diligence and extraordinary circumstances, that would be sufficient. That's the truth.
Okay, so how about diligence and now it's actual innocence of the sentence? What do you say there?
If it was diligence and extraordinary circumstances, that would be sufficient. And in some circuits, diligence alone would be enough.
What's extraordinary circumstances? The length of the sentence? I mean, so
No.
in other words, if it's a 1 year additional improper sentence, don't worry about it. If it's 10, you do?
No, Your Honor. Extraordinary circumstances as to why the petitioner was,
Extraordinary circumstances goes to due diligence.
in terms of why they were unable to comply with the statutory rules. That's correct. So, for example, the 10th Circuit in United States v. Gabaldon faced a situation in which the petitioner was writing his petition and prison officials took the papers from him, refused to give them back. The court there found that was extraordinary circumstances, and the petitioner had demonstrated in writing numerous attempts to get them back and noted the problem with the court. That's far removed from what has happened with Mr. Tiller, who merely asserts that he got confused in the record at page 10. That's his only assertion for why the timing provision should be relaxed. That is simply not enough. It doesn't constitute diligence, does not constitute extraordinary circumstances. Those are the only factors that are related to why one did not file on time. Again, this was totally within the control of Mr. Tiller. Had he filed...
If we follow the language of the Sixth Circuit as opposed to the holding, I take it you lose there.
No, Your
The
Honor.
language is pretty broad,
It is true that the Sixth Circuit phrased its holding broadly in Souter.
and it's a pretty good circuit.
Yes, Your Honor. However, just after Souter, in Ross, they again noted the limitations. Mr. Ross, in that case, was very similar to Mr. Tiller. He was attacking an application of a statute that increased his sentence and presented no new evidence. The Sixth Circuit dismissed that as not fitting within Souter's rule.
There's no new evidence is pretty silly here, because who needs new evidence? It has nothing to do with it. Everyone admits that it was a mistake, so that seems like a very funny thing to use to distinguish the case. There never would be new evidence.
There wouldn't be new
I
evidence.
mean, what, you wanted to get an expert from the law school to say, oh, we really shouldn't be doing this under state law?
No, Your Honor.
It just would be pointless.
It's only pointless to the extent that Mr. Tiller didn't file on time. Again, this was Mr. Tiller's responsibility to comply with the statutory rules or present a reason for not doing so, a good reason for not doing so. He's failed both of those tests. So he does not fit within the statute, does not.
So your view is that if you don't come within any exception of the statute, you're out of luck, period.
Or
Isn't that your ultimate view in reading the statute, that the courts ever responded to judge-made rules that Congress didn't like, and they were saying no more judge-made rules? Is that your point?
Not precisely, Your Honor. Equitable tolling, the state concedes equitable tolling as a general matter is still allowed. But
Even though it's not in the statute?
that's correct, because
And so why stop there?
Because the Supreme Court in Irwin v. Department of Veterans Affairs noted that unless Congress makes it a jurisdictional statute, we assume equitable tolling is allowed. We presume Congress knows of it. That's acceptable. Looking to the merits on equitable tolling, which had never happened before, is unacceptable. We can't presume that Congress was aware of that rule. So that's why this court should not be.
Well, but you can't say that it turns on whether Congress is aware of a problem that had never arisen to decide whether they meant to correct the problem they didn't know about.
It's not solely that, Your Honor. It's that Congress foreclosed other types of statutory relief that Mr. Tiller otherwise might be able to file, and that the jurisprudence of equitable tolling, again, as applied across the circuits, simply isn't available to him because it has nothing to do with the underlying merits of his claim.
Shouldn't the district court have held a hearing on this to find out why Mr. Tiller was confused? I mean, after all, he might have been, his confusion might not be inconsistent with due diligence.
Well, with respect, Your Honor, the Rule 5 of the rules governing 2254 cases allow a district court to dismiss on timeliness grounds independent of looking at the merits. Indeed, before the merits are even, the record is before the court. That's what the court did here, and the burden is on Mr. Tiller to demonstrate diligence. It's for those reasons that this court should affirm the district court's denial of equitable tolling. Thank you.
May it please the court, my name is Lee Peifer for the Attorney General of the State of Lyle. This court should affirm the district court's refusal to extend the actual innocence exception to cases involving claims of non-capital sentencing error for two reasons. First, the text of the AEDPA amendments to the habeas corpus statute leave no room for such an extension in this case. And second, the interests in comity, finality, and the orderly administration of justice all militate against so broad an expansion of the narrow fundamental miscarriage of justice exception in this case. With respect to the first reason, when Congress passed the AEDPA amendments in 1996, it partially ratified the Supreme Court's existing actual innocence jurisprudence by codifying an actual innocence gateway in 3 separate provisions. Importantly, however, in each of those provisions, Congress restricted the availability of the actual innocence exception to petitioners relying on newly discovered evidence such that no reasonable jury would have been able to convict them of the underlying offense. Mr. Tiller satisfies neither of those requirements, and as the Seventh Circuit recognized in Hope v. United States and Burris against Park, and the Ninth Circuit recognized in Greenwald against Stewart, the actual innocence exception as extended to cases of non-capital sentencing error simply could not have survived the specificity of the AEDPA amendments.
You agree, obviously, that the non-capital sentencing area is covered under the actual innocence exception for sentencing?
Yes, Your Honor. The Supreme Court made that very clear in Sawyer against Whitley. But significantly, the court in that case did not extend that exception to all cases involving claims of sentencing error. Indeed, as this court recognized in some of its earlier questions, death is qualitatively different from any other sort of punishment that may be imposed under our system of criminal justice. The Supreme Court has repeatedly recognized and emphasized that point. And in Dretke v. Haley, when the court declined to answer the second question presented here, it made clear that the question had not been resolved by the court's earlier cases in the capital sentencing arena.
So what do you think, in the context of your argument, it seems like it was teed up perfectly in Dretke for an answer to this question. So what do you make of the fact that the Supreme Court didn't answer it?
When the Supreme Court declined to answer this question, it explained its reasoning very clearly. The reason it decided not to address the question was that it was...
Is that a way out?
Well, it's true that the Supreme Court has not bound the court on this particular question. But in Dretke, the court emphasized that the courts generally must exercise restraint when defining the contours of the procedural default rules to avoid riddling the cause and prejudice requirements with ad hoc exceptions whenever the court deems departure from the rules expedient or perceives an error to be plain.
The appellants say that they are exercising restraint here with their theory because there has to be this eligibility issue right at the outset, so it wouldn't pick up all these other cases, and this would really be a very narrow exception.
Well, with respect, Your Honor, the Supreme Court was relying on the eligibility test as an expedient after it determined that the actual innocence exception should be extended to cases involving capital sentencing error. The availability of an eligibility rationale in other sentencing contexts is not dictated by the court's approach in Sawyer. On the contrary, in Sawyer, the court was relying on the specific Eighth Amendment concerns that arise in capital cases. For instance, there are additional...
Why are capital cases so different from life sentences? I mean, in both situations you die in prison. I mean, they seems enough similarity there. It seems odd to me that you would draw a line between them. And say one after the fact, long after the fact, you can bring the claim. The other one, tough luck. You missed it by one day, you're stuck there for the rest of your life. Doesn't matter if everyone agrees you shouldn't be sentenced to life in prison.
Well, Your Honor, the Supreme Court has repeatedly, in cases like California against Ramos, recognized that death is qualitatively different even from a life sentence. The difference between a sentence of 1 and 100 years is less, the court has explained, than the difference between a life sentence and a death sentence, in part because of the finality aspect that you averted to in your earlier questions. A death sentence is much more final and much more severe than a life sentence or a sentence of 100 years, even if the petitioner would die in prison under either sentence.
Wouldn't this case be somewhat analogous, though, because the finality line that you draw would appear to be a fairly bright line rule that could apply in cases like this that involve habitual offender statutes. The state admits that the statute was erroneously applied. There just isn't a whole lot of brain surgery that has to go on to remedy the problem. So why wouldn't the finality that comes about by a rule somewhat similar to the Fourth Circuit has, not that it's necessarily logical, but they have a rule that says we make an exception for habitual offender cases?
Well, the difference between the line drawn by the Fourth and Fifth Circuits and the line drawn implicitly by the Supreme Court in Sawyer at death turns on the importance of the ease with which you can distinguish between death and other kinds of sentences on the one hand, and the difficulty involved in distinguishing between different kinds of non-capital sentencing enhancements.
In this case, we only have one factor, habitual offender statute. So there's no high ball, very easy to determine. State admits it shouldn't apply. Why wouldn't you just draw the line at that exception?
Because as the dissent from the Fourth Circuit's decision in the Mikola-Yunis case recognized, it's difficult from the perspective of justice to see any distinction between a sentencing enhancement that results from a habitual offender statute on one hand and on the other, for instance, a restraint of the victim enhancement, or perhaps the wrongful calculation of a defendant's criminal history under the federal or state sentencing guidelines. If one kind of sentencing enhancement that extends a sentence by, say, 10 years gives rise to a fundamental miscarriage of justice, why not any sentencing enhancement that gives rise to a similar extension in the length of a defendant's sentence? In short, allowing claims of non-capital sentencing error to fall underneath the umbrella of the actual innocence exception would threaten to dramatically increase the number of claims heard on the merits.
What's your response to the question Judge Gibbons asked of your co-counsel of what is the state interest here? I mean, here, most cases, what makes this case exceptional is in most cases the state does fight the actual innocence, whether it was sentence or conviction. Here everyone admits this guy is in jail for 10 years longer than he should be in jail. I don't understand. What's the downside of confessing error? You don't have to make law. We won't write an opinion. We'll just say, let him out of jail. No opinion, no bad law. I understand the point.
Your Honor, the state has very powerful interests in the uniform and consistent...
Someone in jail for 10 years when you agree they don't belong there.
Your Honor, with respect, the state's position here is not vindictive. This isn't a personal attack on Mr. Tiller. On the contrary, the state is merely trying to uphold the integrity and consistent application of its procedural rules and the federal timeliness requirements under AEDPA. The consistent application...
Nothing requires you to uphold the timeliness requirements under AEDPA. You're allowed to confess error whenever you want and simply say we're letting the guy out of jail. You hold the keys. The courts don't hold, well, we have a set of keys as well, but The point is, you can use the keys first.
Your Honor, the state is trying to reduce the number of federal intrusions into its criminal trials because, as the Supreme Court has recognized,
There will be no intrusion if you unlock the door.
Your Honor, state procedural rules, as the court has recognized specifically in cases like Murray v. Carrier in the actual innocence context, serve vital purposes at trial, on appeal, and on state collateral attack.
How will it promote the interest you're arguing for if we rule against you?
Your Honor, it will not promote the interests in comedy and finality that lie at the heart of the adequate.
Aren't you taking a risk?
Yes, Your Honor, we are. But it's important in light of the Supreme Court's emphasis on the rarity and the extraordinary nature of the actual innocence exception and its advice urging restraint in Dretke v. Haley that this court pay special attention to the values of comedy and finality that are so important in the adequate and independent state ground context. As the Supreme Court recognized in Schlup v. Dello, the threat to those concerned posed by claims of factual innocence with respect to the underlying conviction is significantly less than the threat posed by claims merely related to sentencing. Indeed, in Sawyer v. Whitley, the only sentencing context into which the Supreme Court has extended the actual innocence exception, the court imposed a greater burden on petitioners seeking to challenge their sentences than it would have if the petitioner in that case had only challenged his innocence of the underlying offense. The court's skepticism.
Do you agree that appellant has a legitimate underlying claim to which this gateway would pass?
No, Your Honor. In Dretke v. Haley, the Supreme Court, in giving its reasons for declining to answer the difficult question in that case, noted in passing that the Jackson claim that the petitioner would have been able to bring in a wrongful conviction case, the insufficient evidence under the Due Process Clause claim, was not clearly established in the sentencing context. If this court excused...
Yeah, but that just proves it hasn't been decided one way or another. We have to decide that, don't we?
Only, Your Honor, if you decide that the petitioner deserves access to the actual innocence gateway. Under the clear terms of Section 2254E, because the petitioner in this case failed to develop the basis for his claim in state court proceedings, he deserves no opportunity.
What more was he expected to do? He got the state to admit he shouldn't be there.
Your Honor, the state conceded the erroneous application of the habitual offender statute on state collateral attack. Lyle's Rule of Criminal Procedure 32.2a required Mr. Tiller to raise that claim and develop it either at trial or on direct appeal. He procedurally defaulted that claim by failing to comply with that adequate and independent state rule. And, as the Supreme Court recognized in Shriro against Landrigan, a petitioner's failure to develop the basis for claims in state court proceedings under Section 2254E includes a petitioner's failure to properly develop the basis for those claims by, for instance, failing to comply with a legitimate state procedural rule. Allowing Mr. Tiller access to the actual innocence gateway here would therefore have the perverse effect not only of defying the terms of the statute with respect to him, but also by allowing a petitioner challenging only his sentence to proceed on the basis of previously discoverable evidence, where the terms of the statute would expressly require a wrongfully convicted petitioner to present newly discovered evidence in support of those claims. This result would be inconsistent with the Supreme Court's emphasis in Schlup v. Dello on the difference between the injustice that results from an erroneous conviction on one hand and the imposition of an erroneous sentence on the other.
Oh, go ahead.
Am I correct in the bottom line of your position is in the sentencing context, miscarriage of justice, wrong examination, unless you're sentenced to death, there's never a circumstance where you get through that gateway?
Yes, Your Honor. That is clear from the language of the statutory provision relevant to this case and clear from the Supreme Court's precedent on the issue, emphasizing the distinct nature of the death penalty and the difficulty with which the difficulty in conceiving of actual innocence in the sentencing context generally. In Smith v. Murray, for instance, the first case in which the court even suggested that death penalty claims might warrant the availability of an actual innocence gateway, emphasized that the distinction between factual and legal innocence that's so important under the miscarriage of justice doctrine is less easy to understand in the context of a sentencing claim. As the Eighth Circuit recognized sitting en banc in Embry v. Hirschberger, the claim, a legal claim, essentially, that a substantive criminal statute has been wrongfully applied to facts can always be converted into a claim that the underlying facts didn't support the conviction or the underlying sentence. But that would prove too much. because it would essentially undermine the barrier to post-conviction relief that the narrowness of the actual innocence exception was designed to erect. In short, the petitioner's argument here would allow a showing of mere prejudice to swallow the cause requirement under the procedural default rules. That's a result the Supreme Court has specifically and repeatedly cautioned against. For instance, in Murray...
But not prevented, and expressly allowed in the death penalty context.
Yes, Your Honor. But again, death is qualitatively different, and the slippery slope that arises when you allow the availability of a gateway to petitioners challenging some non-capital sentencing claims doesn't apply with respect to the barrier between capital sentences.
What's your response to the question I asked you, your co-counsel, that the state is always, or generally, the set of lawyers that is arguing death is not different? That constitutional provisions and statutes generally apply the same regardless of the underlying sentence that awaits if there's a conviction.
Your Honor,
That's the norm, and here the state is saying something very different.
yes, often that is the case. But the Supreme Court has indicated in a series of cases that specifically with respect to the imposition of a death sentence, additional procedural protections are required. For instance, a necessary finding of aggravating factors to make the petitioner or the defendant in a death penalty case eligible for that punishment. Those protections aren't available outside the death
It's
context.
just the way the common law moves. You take the worst situation, death, you create some exceptions, then you create some exceptions for life sentences, and you create some exceptions for 10-year sentences that everyone agrees are wrong. So we're just down the road.
Well, Your Honor, that's in large part the problem with beginning to extend the actual innocence exception beyond the narrow confines where the Supreme Court left it in Sawyer. The Supreme Court emphasized in Schlup that to ensure that the exception would remain rare and be applied only in extraordinary cases, that they limited it to claims of factual innocence. Although Sawyer extended that exception, grappling with the difficulty of erecting some sort of definition of innocence in the sentencing context, to extend the exception beyond the death context would threaten to dramatically expand the scope of the exception in the federal courts, in the process undermining the important values and interests in comity and finality served specifically by state procedural rules.
If we were going to create some exceptions, in addition to those that the Supreme Court has created, wouldn't this case where the error is so clear, the Senate, and involving a significant term of imprisonment, wouldn't this be at the top of the heap in terms of the kinds of exceptions we want to create?
Well, Your Honor, there are two responses to that. The first is that I see my time has expired. May I have leave to answer your question? The first is that the actual innocence exception applies not only in cases of procedural default, but also to cases involving successive and abusive claims. And extending the exception would undermine congressional purposes in reducing those abuses. The second response is that claims of actual innocence are different in an important respect than claims of sentencing error. They're rare, whereas claims of sentencing error are not. And for that reason, this court should affirm the district court's opinion below. Thank you.
I believe there was some rebuttal time reserved.
Counsel, you would agree that the appellant has shown zero diligence in this case?
Yes, Your Honor, he was not diligent under the terms of under the term as it's traditionally thought. He was confused about the appropriate timing of filing and about the application of the law to him when he was presented with an erroneous paperwork from the state.
He also has shown it in the gist in the context of habeas jurisprudence, neither has shown cause.
Yes, Your Honor, cause looks at diligence, but the fundamental miscarriage of justice, which is actual innocence, is an exception from cause and prejudice. And the Supreme Court announced that because of the fundamental equitable concerns that underlie the writ of habeas corpus. The state has relied primarily on 2 points, that death is different and that the AEDPA simply forecloses this type of actual innocence. The Supreme Court, however, has said contrary. In the habeas corpus context, death is not different. And the Supreme Court said that in Murray v. Giartano when it noted they had repeatedly refused to hold that because a death sentence has been imposed, a higher standard of review applies. And in fact, in Sawyer, the court never noted that it was making the extension because of the death sentence. It merely wrestled with the appropriate standard. Moreover, the state relies on Section 2254E2 of the AEDPA as foreclosing any type of actual innocence exception for a sentence. But in House v. Bell in 2006, the Supreme Court noted that that section specifically does not apply to this type of case, a first federal habeas petition alleging actual innocence based to overcome a procedural default. The
What
fifth.
do we do with the fact that clearly the Supreme Court does think death is different, that they take more death cases in the criminal arena than anywhere else? They have said something along those lines in some cases. I mean, we're the junior varsity, they're the varsity.
Your Honor,
Excuse me. We should pay attention to that, shouldn't we?
Your Honor, the Supreme Court does in some contexts say that death is different, but in the habeas context, it is said the opposite. Therefore, we respectfully request this court reverse the district court's denial of the petitioner's habeas petition. Thank you.
The judges will now return to chambers to deliberate. All rise.
Good afternoon. Good afternoon. All right. As Rob introduced me, my name is Stephen Anthony. I proudly served as the chancellor for this year's competition. And in that role, I've had the privilege of coming into contact with excellent advocates in both their oral and written skills. And today, I have the privilege of recognizing a distinguished few of those advocates from the first and second round. We will recognize first the Paul Hastings Best Oralist Award winners from the first and second rounds, and the McGuire Woods Best Brief Award winners from the first and second rounds. The Best Oralist winners have demonstrated their excellence in advocacy by persuasively and passionately representing their clients while handling difficult and poignant questions from a panel of mock judges. Similarly, the Best Brief Award winners have demonstrated excellence in persuasive writing, which necessarily requires an ability to master and utilize the English language as well as legalese. So now to the winners. We begin by recognizing the winners from the first round, and we ask that when your name is called, you come forward and be recognized. For the Paul Hastings Best Oralist Award winner for the first round, Ms. Lenora Pettit. So good she's not here. For the McGuire Woods Best Brief Award winner from the first round, Mr. Emmerich Regg. For the second round, the Paul Hastings Best Oralist Award winner is Mr. Casey Lee. And finally, for the McGuire Woods Best Brief Award for the second round, we recognize the team of Ms. Yin Yan and Mr. Christopher McCoy. Excuse me, Mr. Yin Yan.
Well, in the interest of easing the tension in the room, we will announce the winners first and then have a few comments about the competition. First, the winning team overall, the appellees Benjamin Holley and Lee Peifer. The best brief, that of the appellants Landon Allred and Aaron Shepard. And the best oralist award goes to Lee Peifer.
let me just make a few comments, but we will be brief. The overall quality of the participation, both the written and the oral advocacy, was of course superb. We're functioning in an area where we were drawing, I think, the teeniest, tiniest distinctions. All four of you were excellent. Both of the briefs we judged were excellent. I don't think the judges could have asked for anything more in terms of the quality of the competition. I know I speak for all three of us in saying that we are the beneficiaries of being here and having listened to the four of you and having read your brief. This is hard. We walked out there and I said, I'm not smart enough to do this. And I didn't mean that I wasn't smart enough to understand the problem. It was an excellent problem, and I hope I did indeed understand it. But I meant I wasn't smart enough to make the sorts of decisions we were called upon to make this afternoon. In many ways, it's a lot easier to decide what you think about the merits of a dispute before you than it is to make the kinds of judgments we were called upon to make about the quality of the briefs and the quality of the arguments. For three appellate judges who hear lawyers all the time of vastly different degrees of ability and expertise, I must say that the facility with which you all handled the arguments, the legal arguments, the precedents you cited was truly impressive, as was the poise you demonstrated in an extremely challenging environment, or one that was is challenging. We tried to make it challenging, I confess, because that's what you're supposed to do when you're invited to judge moot court. And I always feel a little guilty about that because that's not my natural bent. But we did try to make it challenging for you, and you rose to that challenge extremely well. And I thank you for the opportunity to be here and to have heard you this afternoon. Judge Sutton?
Well, I kind of enjoyed giving hard questions.
Well, I was going to.
So much nicer than I am.
I was going to say that, but I held back.
Yeah, she's just so much kinder. So you guys were great. We were not holding back. That's just the way this issue would have been argued if it had been at the Sixth Circuit. In fact, I wouldn't be surprised if the quality of the advocacy here was better than what we would see in the Sixth Circuit. It's really quite good. And you should all feel great about getting to the Final Four. I'm still bitter. I went to Ohio State, and this panel would probably say that it's a lesser law school than UVA. And I didn't make it out of the round of 16, and I am still really bitter about it. So congratulations. I have just 2 points. They have nothing to do with what you guys did, because you were great, but they're just 2 things I like to say because I think they're really important about oral advocacy. You can't get anywhere in this if you don't have a theory of the case. The whole point of oral advocacy is drawing lines. That's what the panel's going to ask you to do, and you've got to know when to make concessions, which are very much credibility enhancing, and when not to, and that just requires a theory of the case. If you don't understand the case, you're just going to be swimming, and all 4 of you clearly could do that. The other thing, just a word about using cases in oral argument as opposed to using cases in briefs. Obviously, they're important. They're very important here because in this particular case, there were some Supreme Court precedents that were on point, some Court of Appeals precedents that were on point. But just a word of caution. When you mention a case in an oral argument, unless it's just the whole case turns on it, you're going to get 1 of 2 responses. First possibility is you're going to get the judge that knows the case very well, and they're going to respond very quickly to your point and explain to you why that case is distinguishable. So you've scored nothing. Second possibility is you get the judge that doesn't know the case, and you're not engaging anybody. So the key thing to do is know the cases, be prepared to talk about them if the panel asks, but you got to talk about principles. Courts of Appeals, appellate judges are very good about talking about principles, and kind of the more you do it, with the cases in reserve, if you need to, if someone says, okay, what's your support for that? You're ready to go with it. But talking about principles is always a better way, in my view, to engage an appellate court, or for that matter, a district court. And I thought all four of you guys were great on that. You understood that perfectly, but I can't emphasize it enough in terms of being an effective appellate advocate. But and thanks for inviting me. I'm the one out-of-stater here, I guess. Well, you're out of state now, so I really appreciate it, and particularly appreciate such a good problem. And I now know this area of the law, which is great. I feel like I didn't know it before today, but I'm ready to go.
Well, it matters less that we know it in our circuit, apparently.
Yeah, that's true. That's true. Yeah, whatever did happen on that panel. All right, Judge Agee.
Well, I want to compliment the Moot Court Board on the way you put this entire program on, and particularly in how you created the problem. That's very difficult work, and you all that did that really did an excellent job, because it's so hard to find a problem that really doesn't lend itself to an easy legal resolution and gives each side an equal chance to be able to compete. That's hard to do, and you all did a great job. And I also appreciate the opportunity to come back to the law school. Judge Gibbons and I were talking about our impressions the first time we saw the law school, which used to be over on the main grounds. And my analogy the first time I saw it, because where you're sitting today was just trees. And my analogy to the law school building at that time, when I was the first class to walk in the door, was it was a cross between some buildings I'd seen in East Germany and some buildings I'd seen at Fort Bragg, and I couldn't tell what was what. So you really have a wonderful facility today that is so much different from what we experienced, and you're fortunate to be able to have this opportunity. I hope everybody takes advantage of it. You all on both sides did an excellent job. You have a great future as appellate advocates. I'll mention a couple of things in general that won't really apply to what you said, but I think may be helpful for all of you that will want to do appellate work. Both sides did a really good job, I won't say of finessing the facts, but giving them the proper scope. Most appellate arguments you make, the judges will be as familiar, if not more so, with the facts than you are. And really, once you've just laid the very basics, I think moving right into your argument, which both of you did, is the right way to go. It's the best use of your time, and it shows you've got a good command of the subject, and both of you all did that well. You had very precise arguments for both sides of the issue. But in the real world, when you're arguing cases, your goal, of course, is to promote the law, but you also have the goal of representing your client. You want your client's side to win. And in that respect, it's great to be able to swing for the fences and have this clear, bright line rule, but appellate judges and trial judges are like everybody else. They may not always want to reach for the bright line, and they may not want to reach for the home run. And if there's some sort of an intermediate fallback position that's still principled, you have an obligation to your client to be able to give that to the court. So you can make a powerful argument for the principles that you have, but if there's some other fallback position, you don't want to ignore that in your brief, and you don't want to ignore that in your oral argument. So for instance, in this case, the Fourth Circuit has a position, which may have been evidence for my questions that I have some doubt about its logic and legal efficacy, but it's a fallback position that's somewhat intermediate. So when you're making arguments, regardless of the topic, that's something you want to keep in mind to make sure you've given the court some other way to go if it doesn't buy your first argument. But you all did a great job. I congratulate all of you on a job well done, and thank the Moot Court Board for having me here.
Well, in closing, I will say just one thing. Judge Sutton may be bitter about never having made it beyond the group of 16, but I think what I'm about to say illustrates really well where these students who've argued before us today are and where some of us were while we were in law school. The Moot Court Board with whom we had lunch asked me if I participated in the Lile competition in law school, and I said, No, absolutely not. There is no way that I would have willingly subjected myself to such humiliation and possibility for embarrassment. I was a shy law student who, for whom misery enough was found in being called upon in class, and I would never, ever, ever have chosen to participate in the Lyle competition. So, from one who couldn't even have made it to the first round, I think that really says I particularly, at least, appreciate the effort you all have given and the skill you've exhibited. Thank you all very much.